Thank you everyone for joining us this afternoon on this important topic. Just a couple quick notes about my firm, PilieroMazza. We are a full-service business law firm. We serve as a strategic partner to government contractors primarily and commercial businesses. In addition to helping our clients with a full range of government contracting matters, from compliance with the federal acquisition regulation to qualifying and complying with the Small Business Administration's regulations pertaining to small business set-asides and eligibility for different socioeconomic programs. We also have a full-service corporate group, a litigation group, and a labor and employment group. Through these services, where we're able to pretty much be a one-stop shop for all of our clients and help them with any matter that might come in the door. As Elizabeth said, I'm an associate attorney in the government contracts group. I also work in the litigation group and the small business advisory services group. So I assist clients in a lot, as it relates here today, a lot of CPARS related issues, past performance issues, bid protests, helping putting teaming arrangements together and counseling our clients through any litigation issues that might crop up either with their subcontractors, for example, or anything that happens with relation to a contract with the government itself. So there's a little bit of an overview today about what we're going to be talking about. The things we're going to be talking about today are the general rules regarding past performance evaluations. I'm going to explain what past performance is, when agencies have to consider it, the different types of past performance information that contractors can utilize when pursuing different contract opportunities, some of the best practices for obtaining positive past performance ratings, and how and when contractors should challenge negative past performance ratings that they may receive, and folded into that is, where past performance is reported, how it's evaluated, when you can challenge it, and what type of relief you might be able to achieve if you do choose to challenge a negative evaluation. So the first thing I want to touch on real quick, what is past performance exactly? Most of you in the audience today probably know, but it refers to the performance that you have on active and physically completed contracts and certain orders under existing long-term contracts. It's important because past performance on contracts is considered a predictor of your capability going forward on future procurements. And agencies are generally required to evaluate past performance and consider past performance information when they're making source selection decisions in the future and determining whether prospective contractors are responsible. So related to that, if you have a negative past performance or poor performance under a federal contract, that can really have immediate consequences for contractors. You could be denied award if you're unable to satisfy the solicitation's past performance requirements, or if you're unable to submit good past performance references for any completed work that you've done. If you have poor performance on a contract, that could result in a termination for default. You could be required to pay damages. So it's got a whole host of implications that are important for both current contractors performing contracts and as you choose to pursue additional opportunities in the future. So just a point of distinction here, past performance versus responsibility. They're different things. Responsibility is a yes/no assessment, essentially. That's usually made at the end. It can be, a responsibility determination can be made at any point during the evaluation process. It's oftentimes made at the very end when considering a prospective awardee. It's essentially whether the contractor has the requisite financial resources, business integrity, and things of that nature to perform the contract. If you are terminated for default on a contract and that is lingering out there on your record, that could result in a non-responsibility determination when you're pursuing future work. So it's really important that you be as proactive as possible, as I'm going to discuss today, and keeping an eye on your performance, ensuring that you have positive past performance and that you continue to utilize that past performance when pursuing new work. Past performance information is one of the several comparative evaluation factors that can be used when a contract is evaluated on a best value basis. In addition to technical and price, it's often one of the most important components. So it really is a critical, it can oftentimes be the biggest differentiator between the agency's choice between two potential awardees. So some of the general rules for past performance evaluations. For negotiated procurements conducted under FAR Part 15, the FAR provides that the agency should consider past performance information from predecessor companies, key personnel, or subcontractors that'll have major or critical aspects on the work when that information is relevant to the instant, to the relevant procurement. So it's important to note here that the should implies that it's really discretionary, and past performance, just generally speaking, when it comes to when the agency chooses to rely on it, how the agency evaluates it, it's one of the most discretionary components of federal contracting. So the agencies do have a lot of range here as far as how they conduct their evaluations and when they choose to rely or not rely on specific past performance references. So with that in mind, the goal today is that some of the information I'm going to share with you and some of the tools that I'll provide will allow you to, not necessarily take that discretion away from the agency, but make sure you're doing everything you can to put yourself in the best position to protect your performance and to utilize it to the best of your advantage. So for IDIQ contract ordering under FAR Part 16, FAR Part 15 does not apply to those types of procurements, and that portion of the FAR says that agencies should consider past performance, again, a discretionary thing on earlier orders under the contract. And for scheduled procurements under FAR Part 8, the FAR simply provides that the agency may consider past performance, but it does not explain what the agency has to consider or really should consider. So negotiated procurements under FAR 15, that's the place where the FAR really provides the highest amount of guidelines as far as what types of past performance the agency should consider. It's important to keep in mind that when you're talking about past performance references here, offerors can submit information on federal, state, local, or even commercial sector contracts. And it's also important to note that the agencies can also seek past performance information from any other source, which again is a very broad allowance on their part. But the key takeaway here again is that the agency has discretion when it comes to what type of information they're going to consider. And if a solicitation is unclear on how the agency is going to evaluate past performance, as I'll get into in a little bit here, a contractor should not assume that they're necessarily going to be able to rely on any of these items noted here under FAR Part 15, such as subcontractor, key personnel, affiliate, or predecessor company past performance. So the first topic I want to discuss today is when can an offeror use subcontractor past performance? This is one of the biggest advantages to putting a team together is that oftentimes, if the procurement is structured in this way and it's to the contractor's advantage, you might be able to, for example, if you have to submit 5 past performance references, there might be primes that don't necessarily have 5 relevant past performance references that would be to their advantage, that have good evaluations associated with them. So by teaming with a qualified subcontractor who maybe has more experience for the specific work you're going after, you might be able to submit some references from that subcontractor, which could really be to your advantage and help differentiate the team from the rest of the competition out there, and would be a distinguishing factor that could really help you win the work. So it is important to know when you can and cannot rely on subcontractor past performance. And the answer is that it really depends on the type of procurement and, most importantly, on the solicitation terms. So for negotiated procurements, FAR Part 15, as I mentioned a moment ago, the agency may consider past performance where the subcontractor is going to perform a substantial portion of the contract. So it's often referred to as a major subcontractor, essentially. FAR Part 8, federal supply schedule procurements, there's no defined rules here, but case law at the Government Accountability Office has sort of crept in to fill in the cracks here. And this case that's referenced here, Atlantic Systems from 2017, GAO essentially established 2 separate default rules that apply where a solicitation is silent on the issue of whether or not past performance is going to be allowed from subcontractors. So in this case, by way of background, the GAO denied a bid protest where the protester had alleged that the agency had erred, and this was a FAR Part 8 procurement, by failing to consider the past performance and experience of its subcontractor. And the two rules that came out of this case are essentially that for FAR Part 15 procurements, an agency must consider past performance references associated with subcontractors for major subcontractors that will perform critical aspects of the requirement. So this increases the bar essentially from discretionary to must, but it assumes still that the subcontractor is a major subcontractor. For FAR Part 8 procurements, the agency, however, has discretion. It can completely disregard subcontractor references. So offeror should not assume that a subcontractor's past performance will be considered unless the solicitation itself in a FAR Part 8 procurement specifically says that the agency will allow subcontractor references. So key takeaways when it comes to subcontractor past performance are that you want to seek clarification if the solicitation is not clear. And today I'm going to talk about that a lot, just generally speaking, really being proactive in this area of the law is how you can set yourself up for success in the best way possible. So if you are intending to rely on subcontractor past performance, it's going to be to your advantage. You look through the terms of the solicitation. If either you can't determine whether or not a subcontractor reference is going to be submitted would count, or in conferring with counsel, you can't reach that determination, you might want to seek clarification with the agency. You can do this through a Q&A, informally reaching out to the contracting officer during the proposal period and advocating as to why subcontractor past performance should be considered. And if that's not something that works for you, if the agency is not amenable to allowing subcontractor past performance, it's possible that you might want to consider protesting the terms of the solicitation. If you do plan, however, to rely on subcontractor past performance and it's allowed, it's clearly going to be allowed, then you want to make sure that when you're drafting your proposal, you want to clearly call out the name of the subcontractor and what their work and responsibilities under the contract are going to be if awarded. Because the key here is that if you're in a situation where a subcontractor reference is going to be considered, that's got to be a major subcontractor. So you don't want the agency to have to do the work to figure out whether or not they should accept this reference. You want to make that abundantly clear. You want to map out all of the different things a subcontractor is going to be doing so that there really is no question that they're a major subcontractor, and so that you can confidently submit your proposal knowing that that reference is going to count and going to be considered. So some solicitations, however, in how these are crafted, it's important to keep in mind that they might provide that subcontractor references will be given weight relative to the amount of work under the requirement that the subcontractor is going to be doing. So that really does put the burden on you to tell the government what percentage they're going to be performing, what their level of effort will be, maybe specifically what tasks are going to be assigned. So in drafting your proposal in response to a solicitation like that, you really might want to consider breaking down the level of effort by each section in the statement of work and identifying or assigning discrete tasks in your proposal to the prime and to the sub, so that it's clear and so that you set yourself up for success during the evaluation process. So the next thing, harkening back to the earlier statement about the different categories here of past performance that can be considered. Beyond subcontractor past performance, key personnel can be considered. So when can an offeror rely on past performance associated with their key personnel? GAO has held that solicitations that expressly prohibit an agency from considering key personnel do not violate the FAR. So this, again, is in line with the fact that the agency really has a lot of discretion in this area when it comes to how they do their evaluations. That being said, however, GAO has also held that where solicitation provided for consideration of past performance of offeror's management team, the agency was required to consider past performance of offeror's managers. So a lot of times here, the solicitation is going to control. That's why it's very important that you review the terms of the solicitation at the outset, and you to the extent possible, try and shape the terms of the solicitation if it would be to your advantage to have certain types of past performance considered. Because as I'll discuss in a little while here, if you're looking at the terms of the solicitation and the way that they're set up with respect to how past performance references are going to be considered, before you submit your proposal is really the time that you can make issue with what is being considered and what is not going to be considered. If you wait and then on the back end, after the award decision comes out, you find out that your past performance of a subcontractor or key personnel or an affiliate was not considered and you want to take issue with that, if the solicitation didn't clearly say that that type of reference would be considered, or even worse, said that that type of reference wouldn't be considered, you're going to be without jurisdiction at that point to challenge that type of determination. Your challenge would essentially be deemed untimely. So it's very important to be proactive about these things on the front end and making sure that you're understanding the terms of the solicitation, because that's going to really set the ground rules for the game. The next area here that I'm going to talk about is affiliate past performance. So when can an offeror use affiliate past performance information when pursuing a contract? So GAO has held that an agency can certainly consider past performance of an affiliate so long as it's not expressly forbidden by the terms of the solicitation. And again, similar to what I was talking about with subcontractors, you want to make sure that the proposal represents the affiliate's resources that are going to be committed to the contract. So for example, you'll want to say, how the workforce, the management, the facilities, or the other resources of the affiliate that you're trying to rely upon are going to be brought to bear underneath the contract that you're going after, such that the affiliate in this case is going to be having a meaningful involvement in contract performance. So meaningful involvement with respect to affiliates is really the key indicator here. And that's going to be determined, though, on a case-by-case basis. But what is clearly certain is that just identifying an affiliate in your proposal is not going to be enough to get across the threshold there into establishing that they're going to have meaningful involvement, and therefore a past performance reference associated with the affiliate can be submitted and relied upon. So when you're trying to consider how you're going to rely effectively on affiliate past performance, you want to see how you can maybe use that affiliate to support the actual work. You could maybe, to make things easier here, bring them in as a major subcontractor, or you could rely on them as a resource for key personnel. And also you could perhaps try to submit a bid with your affiliate as a joint venture, in which case you would be able to rely potentially on the different references of those joint venture members. Again, though, if you're planning on relying on affiliate past performance, you're going to want to make sure that the solicitation clearly allows it, because this is an area where the agency has lots of discretion. So you don't want to find yourself in a situation where you've relied on affiliate past performance. It's not abundantly clear that you can do so in the RFP, and the agency chooses to disregard that reference on the back end. So for some examples here that I want to give of ineffective use of affiliate past performance, there's a GAO case that essentially held that a proposal did not provide a reasonable basis for the agency to consider an offeror's affiliate past performance, where the two different companies, the offeror and its affiliate, shared management personnel, but the proposal did not clearly commit either of those management personnel to perform under the contract. So it really is about meaningful involvement. So again, this is an area where you're going to rely on affiliate past performance. You really want to make sure that your proposal clearly identifies how that affiliate committed to work. There was another GAO case where GAO denied a protest because even though the protester's proposal included a narrative which purported to demonstrate that its affiliate was going to be meaningfully involved, the narrative just described a general administrative support without identifying any firm commitment. And it also didn't indicate which affiliate would be providing support. So you want to establish things like this person is contractually providing certain types of resources that are actually going to be brought under the contract and contribute to performance. Examples of effective use: the GAO found that an agency properly considered experience of a sister company where The offeror's proposal describes the relationship between itself and its sister company. It describes the resources that the parent company and the sister company would be using in performance of the contract. It described how many of the key personnel from the company's leadership were employees of the sister company or the parent company, and there was an unconditional commitment of financial resources and capabilities from the parent company and its family companies. So it really is, again, a commitment to performance that's going to get you home here when it comes to affiliate past performance. One aside here for anyone in the audience who's listening today as in a tribally owned company, just use caution when you're relying on affiliate past performance information. Generally speaking, tribally owned concerns receive a very broad exclusion from affiliation for 8A procurements. But that being said, they can be found affiliated for other reasons under small business set-aside contracts. So you want to be cautious here, because if you're relying on past performance information from your exempted affiliates when bidding on procurements, that reliance could be an additional piece of information that could be used to tie you and your affiliates together through a finding of general affiliation, which would have size implications that could cause you to exceed the size standard and therefore be ineligible for award. The next big area here that comes up a lot is, when can a joint venture that's formed between companies, oftentimes joint ventures are formed specifically for a solicitation, and the joint venture itself might be going after a contract, and this could be its first contract that hasn't performed any other work. When can a joint venture like that use the past performance information associated with its individual members? So in this area, the FAR really doesn't provide a whole lot of guidance, but GAO has historically upheld crediting a joint venture with the past performance of its joint venture partners. And in fact, SBA's joint venture regulations were revised a few years ago in 2016 to expressly require agencies to consider past performance information from each joint venture, as well as any work done by the joint venture itself. This obviously assumes that the joint venture at issue is a FBA small business joint venture. However, keep in mind that when the JV is between an SBA approved mentor and that mentor's protege, the agency in issuing a set-aside procurement for such a contract can limit, in the terms of the solicitation, the amount of mentor past performance that will be considered. So if you've got a joint venture between a large business mentor and they're receiving the exemption from affiliation, and they're partnering up with their protege that's maybe a small, inexperienced company that's just getting started, and they're going after a small business set-aside, that joint venture is going to want to submit past performance references, but the protege, who may be relatively inexperienced, might not have a lot of references. Could be one of the first contracts it's going after. So while the SBA has indicated that in evaluating such a joint venture, the agency is going to have to consider some of the mentor JV partners' past performance, they could certainly limit it if, for example, let's say the solicitation required that the offeror submit 5 past performance references. Well, there's been cases that have certainly said that an agency, through the terms of an RFP, can limit the mentor's contribution to those references to, for example, 3 of the 5. So to submit 5, the mentor can only submit 3. The protege would have to submit 2 or submit none, which could obviously have an impact on that joint venture's ability to get the contract. Agencies can also consider each JV member's relative level of effort as part of its past performance evaluation. And the agency can still require that the joint venture submit past performance of its own, which may be difficult. Certainly if joint venture is formed specifically for the contract, it might not have any past performance of its own. So related to this, another issue that comes up often is, when can an offeror use the past performance of a joint venture in which it was a member? Let's say, for example, a mentor and a protege are in a joint venture. The large business mentor really helps out the protege and gets a great contract, and they want to say, well, hey, how do I rely? I want to use that contract reference going forward and pursuing my own work, and vice versa for the protege that then wants to set out on its own and pursue some of his own contracts as a prime contractor, but maybe the only big contracts it's performed so far are through this mentor-protege joint venture. So the only clear rule is that you can rely on past performance of a joint venture you were in as a member when you were the managing member, meaning at least the 50% partner of that joint venture. And the way that you can, the analogous way to sort of rationalize why this works is because if you're the managing member of the JV itself, you're going to be affiliated with that JV. You control that JV. So that JV is essentially an affiliate of yours. So it would essentially be the same sort of analysis as we talked about earlier with respect to how you use past performance associated with an affiliate. So OHA has announced where an offeror relies on past performance of the firm as a participant in a joint venture, the agency can consider the performance on the basis that the offeror had a sufficient role in the joint venture to make the performance relevant. Again, there's some vague terms here. It's not really clear what sufficient role means, but as I just noted, GAO's compared that analysis to that of an affiliate. So if you were a 50% managing member and you were performing 50% of the work, then as we were talking about with affiliates, that's going to probably be viewed as meaningful involvement, which means that you contributed to that specific contract at a meaningful level, and that therefore you should be able to rely on that reference. Another question that comes up often, given that there's so many large schedule contracts out there established by GSA, is what about contractor teaming arrangements set up under GSA schedules? So a contractor teaming arrangement, a CTA, that's a written agreement between two or more scheduled contractors to work together to meet a specific agency requirement. Unlike a traditional prime subcontractor relationship, each member to a CTA is responsible for its specific duties. Each member has privity of contract with the government, and they each must have the specific GSA schedule contract under which the procurement is being established. So here, since each of the members actually has privity of contract with the government, the argument can be made that all CTA offerers should be able to rely on past performance information associated with each CTA member. But if reliance on a CTA member's past performance information is unclear in the solicitation, offerers would certainly be advised to consider seeking clarification from the agency, because it's just past performance is a very important area, and there's a lot about it that you don't want to have issues on the back end, and it can often be, procuring agencies themselves make a lot of mistakes here. This is something that we see crop up a lot on our end. So the more proactive you can be, the better. So even if you think that you're on good footing to rely on the past performance of each CTA member, unless the solicitation really spells that out, it might be behoove you to clarify that with the CO before getting your proposal in. And if for whatever reason the solicitation states that you can't rely on the past performance of each CTA member, you might want to consider filing a protest. So the next area here, as I mentioned earlier, FAR 15 says that agencies should, again, discretionary, rely on the past performance information of a predecessor company. The predecessor company is an entity that's replaced by a successor, and a successor is an entity that has replaced the predecessor by acquiring its assets and carrying out the affairs of the predecessor under a new name. This is often done through acquisitions or mergers, but this does not include new offices or divisions of the same company, or a company that changes its name only. So the way that this most routinely comes up is through the novation process. You acquire another company, you go through a merger, acquisition. Although transferring contracts is expressly precluded by the Anti-Assignment Act, you can't buy a federal contract. The novation process is an exception to that, which allows the government to transfer the contract from one party to another, and in doing so, recognizing the acquiring company as a successor in interest to the acquired company that's performing the contract, usually done when you're acquiring all of the company's assets, all of the resources used to perform the contract. Now, when contracts are novated, they're assigned the cage code of the successor entity, which means that after the novation is completed, the predecessor's contracts should all show up in the CPARS system under the successor's cage code. So you would think that now these are essentially all under your umbrella. Great, I should now be able to rely on any of those references going forward for any procurements I'm going after, but that's not necessarily the case. GAO has clearly said that novation alone does not require an agency to attribute the past performance of a predecessor company to its successor company. And the key thing here in the case cited here, Civatec in 2012, GAO said that neither the express terms of the novation agreement that is signed in these situations, nor any other authority of which we are aware, provides for the legal fiction that the protester, in this case Civatec, was entitled to claim as its own the experience of another unrelated entity. So again, you're going to have to do more in some cases than just establish that there was a novation for you to be able to rely on the performance of a predecessor company. The key consideration, according to GAO, is whether the experience evaluated reasonably can be considered predictive of the offeror's performance under the contemplated contract. So I'm going to go through some examples here of successful use of a novated contract. So GAO has upheld an agency's past performance evaluation that relied on novated contracts where the successor in interest under the novation agreement is essentially the same entity. So in Davis Strategic in 2016, GAO found that an agency could properly consider the past performance of a predecessor where the experience of that company is useful in predicting the offeror's performance under the contemplated contract. In DynCorp 2016, GAO found that where contract performance was continued on the novated contract, then it's reasonable for the procuring agency to consider those novated contracts in evaluating experience and past performance. So the key takeaway here, the big question is, can I rely on the past performance from a novated contract? As I've said all along here, evaluation of experience and past performance is a very discretionary area, a very big discretionary area for the agency. But if you can show that the novated contracts are predictive of future performance, so for example, the entities involved are essentially the same, it's just a continuation, or the personnel that were previously performing the contract are now working under the successor company, or the transferee entities has actually performed on the novated contracts for some measurable period of time, then you may be able to rely on those contracts for purposes of past performance. I would just note a couple things here as well. In addition to past performance, a contractor may be able to rely on the experience of a predecessor firm or the predecessor firm's principal officers under the experience evaluation factor, which is usually called corporate experience, which is separate and apart from past performance, but just keep that in mind when you are going through a novation. In addition to acquiring past performance, you may be able to acquire corporate experience, which can be another differentiator when going after federal contracts. Also, another thing to consider for people in the M&A space, an agency, the goal here is obviously how do we acquire and use helpful past performance references that are going to help our company win government contracts. But keep in mind that the agency can also consider negative past performance information that you acquire. So just want to be cautious here. If, for example, you're acquiring a poor performing company, you're acquiring all of their assets out of bankruptcy, it's possible, since agencies, in addition to the references you submit for past performance, they can use any other sources of information they want to evaluate your past performance. If you are now the successor company to a predecessor company that was a poor performer and had really negative past performance, maybe had been terminated for default, things of that nature, that could actually be a hindrance to you. So just keep that in mind if you're acquiring distressed assets or a poor performing company that's in bankruptcy for something. So here are some key takeaway tips here for the best uses of past performance information. You really want to try to shape the solicitation requirements to fit your needs. This can be done, as I mentioned earlier, through informal dialogue with the agency, the core, the CO. You could submit comments to a draft solicitation. There are sometimes Q&As with solicitations. That would be a great time to also try to advocate for the position that you're trying to pursue. You can also, if none of those informal avenues work, you can protest the terms of the solicitation themselves. In this case, when it comes to past performance, the idea is that the terms and the evaluation criteria are unduly restrictive, or if they're ambiguous. For example, it's not clear whether major subcontractor past performance is going to be considered. But the key thing to keep in mind is that once bids are submitted, the proposal submission date rather has passed. It's too late to challenge the evaluation criteria. So you want to be as proactive as possible in making sure that when solicitation hits the street that you're interested in pursuing, you review the terms, you review the evaluation criteria, the instructions, you really wrap your head around how the evaluation is going to take place, how the agency is going to weigh and consider past performance, and then to the extent necessary, you put together a list of things you want to clarify with the agency, maybe additional past performance references that you would like to submit or that you would think would be helpful to you, and you want to see if you can sort of bake those into the solicitation through dialogue with the agency and advocating your position. This is something we often help clients do when they see a solicitation that comes out and for some reason or another, it's restricting consideration of past performance from key subcontractors. Our clients may be relatively new, they're just getting into a new area that they haven't worked in a lot, they don't have as many references there, they want to rely on past performance of a subcontractor. So we help sort of advocate with the agency as to why there's no reason that a solicitation should be restricted to preclude that sort of reliance. You also want to make sure that in responding, when the final evaluation terms are set, you want to make sure that your response is really tailored to however that past performance criterion is set up. So first, try and see if you can shape it. Second, make sure that you draft your proposal so that it's really catered and responsive to the evaluation criteria. And then you want to make sure you monitor your sources of information for past performance, because this is where the agency is going to go out and beyond what you might submit, they're going to look at CPARS and FAPIS and other past performance databases, and they might find stuff out there about you that you necessarily weren't trying to rely upon, but it could be used as a discriminator against you. Also, you could just informally ask clients what they've heard about you. It's really important to document things, as I'm going to talk about more going forward here when you're getting to the stage where you're actually challenging negative past performance evaluations. You certainly want to participate in debriefings, because that's going to give you a lot of information about your past performance, how they evaluated it, what references they took into consideration. And then to the extent possible, when you're, and this is something that I think a lot of contractors don't necessarily consider at the outset. It's only when an evaluation doesn't go their way that they, might see this as a bigger differentiator. But if you're setting up a teaming relationship with a subcontractor, you might want to do a little of your own digging to the extent possible to see what information exists out there about that subcontractor, because while they might be telling you that they've done this work forever, they've got great references, you could find yourself in a situation where you're identifying that subcontractor as a major subcontractor, but the agency goes out and does its own digging and finds out that there's actually negative information out there that could hinder you when it comes to the evaluation for a specific contract. So as I've mentioned earlier, if the informal way of structuring solicitations isn't helpful, you can certainly try to protest the solicitation terms itself. Here are just some examples. I'll try to breeze through these somewhat quickly, but they'll be here in the materials for you going forward. But some examples of unsuccessful protests, because again, this is an area where agency has a lot of discretion. In the Valor construction case in 2011, GAO found that a solicitation was not unduly restrictive, where it limited consideration of a team member's experience to firms with which the offeror had contractual privity. So again, this Valor case actually supports the idea that I was talking about earlier, that CTAs, contractor teaming arrangements, should be able to rely on members' past performance because unlike a prime sub situation, all of the members in a CTA have contractual privity with the government. There's also an Olympus building case in 1999. GAO held that a solicitation was not unduly restrictive, where it indicated that past performance would consider only corporate past performance and not past performance of key personnel. Technology and management in 1990, GAO held that solicitation was not unduly restrictive, where it did not provide for inclusion of subcontractors' experience under corporate experience because it was necessary for the contractor to possess relevant corporate experience in order to assure satisfactory performance of the contract. But here are some examples of successful protests in this area. The Total Health case in 2009, GAO held that a solicitation requirement for specific experience on the part of a prime contractor was unduly restrictive, where the agency did not show that its needs could not be satisfied by a subcontractor with relevant experience. There is the Iabach case in 2014, where a solicitation was found to be unduly restrictive, where it provided that experience and past performance of affiliates would not be considered, even where proposals demonstrated that affiliates will participate meaningfully in contract performance. And then in the Navajo case in 1995, GAO held that a solicitation clause requiring specific experience applicable only to fuel dealers and not refiners or manufacturers was unduly restrictive because the agency made no showing and the record provided no reasonable basis for the agency's determination that the restriction reflected the agency's minimum needs. So in general, the big takeaway here is that when you're challenging an RFP's solicitation criteria with respect to past performance, the agency in restricting what you can rely upon, you know, as the FAR says, generally speaking, the agency should consider affiliates, predecessor companies, major subcontractors, key personnel. If the agency chooses to restrict your allowance for any of those areas, they're usually going to have to justify that in some form or fashion. So if they can't, and there's really no reasonable basis for them to be restricting it, that's going to be the basis of any protest in this regard. So how do you optimize your performance? Well, you want to make sure that you're vetting your quality assurance plans and your performance schedules. Documentation is key. So when you're performing a contract, and again, contractors don't necessarily always think of this during performance. You know, certain types of contracts, things just get busy, documentation isn't always kept, and you know, you're working with the government. No one anticipates problems when you're working with a client. You know, you're just trying to help and get the problem or the service done and meet the agency's needs. But you want to always keep in the back of your mind that something could happen, and you want to make sure that you document everything. So one of the things in the past performance area that you can really do to help yourself is keep track of any kudos you receive. And obviously you want to rectify any issues as they arise. But if you can start establishing a record of good past performance, that's going to really help you on the back end should the agency try to indicate that you had poor performance. You want to always be assessing whether you're on track to meet performance milestones. And you want to know the past performance information rating justifications and stay within the contract's period of performance. So unfortunately, it's been, in recent years, I will say there's been a lot of data to suggest that past performance ratings, there's been a huge trend toward the norm in this area being satisfactory ratings. According to the government, they will take the position, and they routinely do, that a satisfactory rating on a CPAR is good because technically, according to the FAR's definition of what a satisfactory rating is, that means that you met the contract requirements. So if the government's going to take that position and they're going to trend all of the CPARs towards satisfactory, obviously any contractor that's been down this road before knows that satisfactory is not good. And often a satisfactory is not going to be enough to differentiate you from the competition. And since past performance can be one of the most heavily weighted evaluation criteria, satisfactory is sometimes not going to cut it. So with that in mind, One of the best things I think contractors can do at the outset of any contract to ensure that not only are they going to get the job done, but this contract is going to then be useful for them going forward and getting other work, is to make sure that they engage with the agency early on to figure out what it's going to take to go above and beyond. Because according to the FAR's definition of the different evaluation ratings that can be assigned for past performance, anything more than a satisfactory rating requires that the contractor exceed some contract requirement and deliver added benefit to the government. So if you want to be proactive here, you should ask the agency early on, hey, what's it going to take? In this case, what would you consider a beneficial added service? Maybe they can say, oh, well, in this case, although the delivery schedule is, X, Y, Z, delivery here is really time is of the essence. And we know that we said we wanted this done in a certain timeline, but we've got all these other things going on. Maybe it's a military base and you've got to deliver, you've got to build something in a certain amount of time. And they say, yeah, we know we gave you 3 months to do it, but actually we've got all these other things going on at that time of year. If you guys can at all beat that schedule, I mean, that would be to us the most crucial added benefit you could give to us. And if you know those sort of expectations early on, you document these conversations with the agency, that means that on the back end, you've got a great way to advocate for higher ratings, because the agency, to the extent, let's say you get a CPAR that's all satisfactory ratings, it might not be worth the time and energy. Some contractors think, oh, satisfactory is fine. I guess this won't be one that puts us over the edge. We'll just be satisfied with the satisfactory ratings. And that could be the case, because it can be hard to fight these things because the agency does have so much discretion. But if you've got a documented record of you set what the expectations were early on and how to exceed them, and then you've got documentation of exceeding them, it's going to be worth it to try and rebut a satisfactory rating, because you might be able to say, hey, look, we asked you, you told us, and we performed. So just keep that in mind as you're, as any new contract comes in the door and you're determining next steps and how you're going to set yourselves up for success. The next area that I want to talk about here is defending your past performance. So agencies have to consider past performance, as I've been talking about, and they have to report it in the CPARS system, Contractor Performance Assessment Reporting System. So the FAR requires agencies to monitor compliance with past performance evaluation requirements and enter past performance into the CPARS system. And CPARS is tied to other databases like the Federal Awardee Performance and Integrity Information System, FAPIS. CPARS, though, is usually the primary source relied upon on source selection officials. FAPIS is going to have a lot more information in it. The two systems are kind of tethered. There's been a lot of transition over the last year between all of these different federal databases that are now getting established under SAM beta, but FAPIS is going to be the place where there's also going to be records of terminations for default and things of that nature. But at the outset here, defending your past performance, the key thing to remember is that, as defined in the FAR, a CPAR evaluation has to include a clear non-technical description of the contract, and it has to have clear, relevant information that accurately depicts the contractor's performance, and it has to be based on objective facts supported by performance data. So the big takeaway there is it's got to be clear, relevant information based on objective facts. And the agencies have to use certain prescribed evaluation factors, including quality, cost control, if it's a cost contract, management, timeliness, regulatory compliance, small business subcontracting. There's going to be a couple of different areas that are going to have to be evaluated depending on the type of contract. Notably, though, the Court of Federal Claims and the boards have found that when CPARs are required and provided, contractors have a right to a fair and accurate performance evaluation. So although this is a very broad area for agency discretion, it's important to remember that you do have rights here that I'm going to discuss, and that you do have a right to an accurate performance evaluation. And although the agency holds a lot of initial power here in conducting the evaluation and what they choose to consider in any sort of rebuttal you might submit, you can escalate a dispute related to a CPAR, and I'm going to get into the details of that. But it's just important to remember at the outset that this is an area that, although the agency has a lot of discretion, you have the ability to fight for what you think is a fair evaluation, and you have a right to a fair evaluation. So I'm going to talk a little bit now about the specifics of CPARS evaluations. So there's a couple different types of evaluations. You're going to have interim evaluations. These are going to be all the evaluations except for the evaluation that's completed at the end of the contract. These are for, our interim evaluations are going to routinely be done for long-term contracts, or at least contracts that have a period of performance that's longer than a year. The first interim evaluation on that type of contract has to evaluate at least the first 180 days and can include the full year. But they're also required at least every 12 months for contracts that exceed a year. Important to note though, and this is, I look at a lot of CPARS and help clients just initially sort of vet, what the agency did or didn't do right in any specific evaluation. I'd like to say, since these are such critical points of differentiation during competition, your CPARS, I would like to say that agencies give these the weight and the consideration that they're due. But unfortunately, working on my side of things, I just don't think that's the case. Agencies are often overwhelmed with various administrative tasks and burdens and responsibilities. And I think that unfortunately, drafting, evaluating, and completing the CPARS portion of contract closeout is regrettably kind of low on the list of things to do. So I am always shocked at the number of technical errors, deficiencies, just inaccuracies that can come up in CPARS evaluations. So I think when you get one of these, the first thing to do is to make sure you distribute it to your different team members and make sure that everyone looks at it, that was performing on the site, and try and flag the issues. Now, final evaluation is going to be the one that comes out at the end of the contract. A lot of times the agency messes up how they do this. They'll give a final evaluation that evaluates maybe more than a year worth of time. That's technically improper under the CPARS guidance. There's a lot of things that can be done just technically deficient when it comes to the amount of time that the agency is evaluating, what they're calling the evaluation, and when they're doing it, because they are supposed to be done promptly at the end of performance. But again, I've seen these come out, a year or two after a contract's closed out. Important thing to keep in mind is that CPARS, which is a past performance reference, that's going to be valid for 3 years. And for generally speaking, for most contracts, that's 6 years, however, for construction and architect engineer contracts. So this chart here is this explains the threshold for when CPARS are required. For those of you participating telephonically that might not have access to the slides right now, there's a bunch of different thresholds. It depends on whether it's a DoD or a civilian agency. Generally speaking, civilian agencies, CPARS are required for anything that exceeds the simplified acquisition threshold. That's $250,000. Or if it's an architect engineer contract, it's going to be anything that's over $35,000. Construction contracts in the civilian space are over $700,000. And then for DoD system contracts, it's going to be anything over $5 million. Non-systems operational support is anything over $5 million. Services and IT, anything over $1 million. Ship repair, anything over $500,000. So there's just a bunch of different thresholds as to when these are required. So it's important to keep that in mind as you're going through the process. I will note for anyone that does work with the Federal Aviation Administration, that agency does not have to comply with the FAR. They have their own policies and procedures. It's called the Acquisition Management System. But since around 2013, the FAA has required acquisition staff to use CPARS for contracts that are over $5 million. And these thresholds that you can find online, the FAR maps out what these different thresholds are. It's just important to keep in mind that the aggregate value, the thresholds apply to the aggregate value of the contract, which means that if a contract's original order or awarded value was less than a given threshold, but the contract's modified and the new value exceeds the threshold, then evaluations are going to be required from that point forward. And agencies can obviously choose to collect performance evaluations for awards that are below these thresholds. So it's just another important thing to keep in mind. Now I'm just showing a quick chart that shows the CPARS ratings and narratives. For those of you on the phone, you can find these at FAR 42.1503. This is table 42-1. I'm just showing this now because it's very important. Anytime you're challenging a CPAR, you want to know what rating you got, obviously, but then you really want to know what the requirements, or I should say, the expectations of that rating are, because that's how you're gonna have to structure any argument. If you got a marginal rating, you're going to want to know what type of performance justifies a marginal rating. And if you think that that performance is not aligned with how you actually performed, and you're going to shoot for, let's say, a satisfactory, a very good, maybe even an exceptional rating, you're going to want to structure any sort of opposition. Excuse me. You're going to want to structure any argument to advocate that your performance was more in line with the higher rating and the definition of what that rating entails. So it's really critical that you know what these are and understand the definitions. So how do you respond to a negative CPAR? So you get a notification in the system that you've received a past performance evaluation. What are the next steps you want to take? Well, as I mentioned earlier, the first thing you're going to want to do is you're going to want to circulate the evaluation to your team members, to the decision makers who are involved in project performance, have them do a run through, flag anything they disagree with, any outliers, any inaccurate information. You'd be surprised, but there is sometimes information in there that's not even related to the contracted issue. So you want to do your best to initially flag all that stuff. The next thing you're going to want to do is you're going to want to calendar and flag your response date, which is 14 days after you first receive notice that the CPAR is available for review. That's your deadline to submit comments, rebutting statements, or provide any additional information you want that explains the different evaluation factors, the areas that are being evaluated. After the 14 days run, the CPAR is automatically published, and I don't mean publicly published, but is automatically published in the CPAR system together with any comments that you've submitted. And it's going to, at that point, be accessible for review by any other procuring agency that's trying to get past performance information about you with respect to a different procurement. So that's going to happen on day 15, with or without your response. So it's really important that you get your response in within those 14 days. Now, that being said, the CPARS system technically allows you to submit comments up to 60 days after you get notification. But if you submit comments after the 14 days, it's not, your comments are not going to trigger a formal review necessarily. So you want to make sure that you get them in a timely fashion. So how do we respond? Contractors often wonder, what should we say? What types of things shouldn't we say? Keep in mind that this is not your day in court writing a CPARS rebuttal or response. So do not put any information in there that's going to cast you in a negative light. Imagine a procuring official reviewing this, seeing how the agency evaluates you, and then, as they're supposed to do, scroll down and looking at your response. You want your response, even if the evaluation is really egregious and you take issue with it, you want to submit a professional response that paints you in a good light and doesn't make things any worse than they may be in the evaluation. But you certainly want to advocate anything you think that is inaccurate. So you want to initially, and this is something contractors can do on their own, but if it's also something that we have a lot of experience in doing, and it's something that certainly there are arguments you might not think to make. So it is something that the council can certainly help you in doing. I've done plenty of them. There's a lot of things that you want to address up front. Sometimes there might just be technical or procedural deficiencies with the CPAR itself. They might be evaluating factors they shouldn't. They might be referencing information that shouldn't be in there. They're only supposed to talk about things related to the specific period they're evaluating. So that being said, sometimes agencies will use this as an opportunity to make broad generalizations about the contractor's performance beyond just the period that's being considered. So if they're evaluating the last 6 months, they might mention something that's happened since then, or they might mention something that happened a year ago. That's all improper and beyond the scope of the specific CPAR issues. So working with counsel, you can really flag what the initial issues are, if there's any technical deficiencies. But you really want to see if you can, this is the opportunity, like I said earlier, if you're being proactive, you're documenting kudos, you've got a good record of notes to the file that indicate good performance. This is your opportunity to now use that stuff to your advantage if you get a negative CPAR. You also might want to consider if you've got proposals that are pending out there on procurements that you're really interested in, you could certainly try to ask the agency to not rely on a specific past performance reference that might come out while that proposal is pending until there's been a final decision, because until the CPAR's been final, it's often not a great representation of what the final evaluation is going to be, because sometimes, it might be more often than not, the initial evaluation is going to at least have some inaccurate information in it, or something that gets revised later. So agencies really should only be relying on what the final evaluation is. So it certainly would behoove you to ask agencies to do that if you get concerned that a negative CPAR is published while you've got some proposals that are pending. So another question that often comes up, you just said at day 15 these things get published. Is there any way we can avoid that? Unfortunately, strictly speaking, no. The government's not required to wait to publish in CPARS the negative CPAR in this case, but they could be persuaded. So if you're proactive in reviewing the CPAR, getting together with your team, maybe getting together with counsel, putting your heads together on what the issues might be, and timely submitting a response, you might be able to then have an informal dialogue with the agency at the outset and say, hey, listen, as you see based on our submission here, we take issue with a lot of statements that are in there. We found a bunch of inaccurate information. We think you failed to consider X, Y, Z, which we documented in our response. And we think that having this negative CPAR lingering out there, given that our 14-day submission is going to trigger a further review of this, and given that the final CPAR might not be in line with what's currently been evaluated, we think that you should withhold publication and that you should pull this down from the CPAR system while we resolve this dispute. The agency, depending on the agency and the assessing official and the CO, they might be inclined to do that. I've had success doing it in the past, so it is something to consider. That being said, it's important to keep in mind that you're not going to be able to get injunctive relief if you have an issue with a CPAR. So the courts and boards have said that a tribunal cannot direct the government they cannot expressly direct the government to revise, remove, or not rely on a CPAR. We've tried creative arguments in this area to get an injunction, but courts are pretty much said that they're not going to accept such arguments. So if you get a negative CPAR, you can't run into court and say, hey, court or Board of Contract Appeals, we request that you demand that the agency remove this, or that other procurement agencies not rely on it. That's not a relief, any type of relief that's going to be available to you. So how do you challenge a negative CPAR? Well, like I said, if you get it in within 14 days, your comments, that's going to trigger a review by a reviewing official at a level above the contracting officer. And that reviewing official then has to issue a written decision, which then becomes part of the evaluation in what's called the final evaluation. This whole process from when you submit your comments to when the final evaluation takes place is supposed to happen within 120 days of the end of the contract period of performance that's being evaluated. And it's important to keep in mind, though, that the ultimate conclusion here and the ultimate evaluation is a decision of the contracting agency. So even though you have the right to a rebuttal, you can request a review at the level above the contracting officer. The ultimate decision again here, given that this is an area with so much discretion for the agency, is a decision made by the agency. That being said, what our usual strategy is to, in addition to what you actually put as rebutting statements into the CPAR system within those first 14 days, if we're engaged early on in the process, we often help our clients not only put together what that narrow response into the system might be, because I believe there's limitations on how many characters you can input and whether attachments can be included, things of that nature. We usually often, at the same time that that is formally put into the CPAR system, we help with an actual letter that we send directly to the contracting officer that is a much longer piece of advocacy that has more legal arguments in it and actually attaches all the exhibits we think justify higher ratings and establish that the current ratings in the narratives are not reasonable. So that's the type of dual prong approach you can take with responding effectively to a negative CPAR. So you get the final decision on the CPAR and it's still not what you like. The agency, let's say they didn't change the ratings, they didn't change the narratives, and they didn't do anything you were hoping in response to your rebuttal statements. Well, there's no formal appeal process in the FAR. So instead you have to look to the Contract Dispute Act and the disputes clauses in your contract. And the Contract Dispute Act permits appeals to the Board of Contract Appeals and the Court of Federal Claims of what are called contracting officers' final decisions in response to claims. So to appeal a CPAR, you've got to establish standing, meaning that you've got to be appealing a final decision on a claim. So in this regard, it's important to keep in mind that the comments you submit in the CPAR system during that 14-day period and beyond, during the evaluation process, are not necessarily going to be considered a claim for purposes of establishing standing to pursue an appeal. So to ensure standing with respect to a CPARS appeal, you want to make sure that you actually submit a separate letter that has all the jurisdictional language in it to establish that you're formally making a claim under the Contract Disputes Act, under the disputes clause of the contract, and that you're seeking a final decision from the contracting officer. Now, once the contracting officer issues the decision on that, now you've got something that you can appeal. So how do you handle an appeal? What's the timing? What's the venue here? Well, claims have to be filed with the contracting officer within 6 years of when they arose. Obviously, I mentioned earlier that CPARs are generally good for 3 years, for construction, 6 years. So that's a much smaller time period. You're not going to want to wait 6 years if you're choosing to file a claim and go down the appeal process. You want to do this quickly. If the CO fails to respond to a CPAR claim that you submit within the required time period, you can deem that a denial and you can immediately appeal that. If the claim is denied or deemed denied, you can appeal to the Board of Contract Appeals or to the Court of Federal Claims. Now, for timing purposes here, you've got 90 days to appeal a final decision on a claim to the board, and you've got 12 months to appeal to the Court of Federal Claims. There's different strategies for going to each venue, but once you choose the venue, you can't switch. Now, how long does a CO have to wait, or how long can they wait to issue a final decision on a claim? It depends on the type of claim. So if the claim's for $100,000 or less, they have to issue a decision within 60 days. If it's for more than $100,000, within 60 days of when you submit the claim, they have to issue a decision or tell you when they're going to issue a decision. For non-monetary claims, they have to respond within a, quote, reasonable time. And usually a CPAR claim is going to be a non-monetary claim. So the reasonable time period is going to be what's relevant here. And the reasonableness of a response, or the reasonableness of how long it takes them to respond will take into consideration factors such as the size and complexity of the claim. Now, why do you want to go to different venues? Both of them have forms of alternate dispute resolution, but at the court, the agency is going to be represented by the Department of Justice. They usually don't want to settle things until there's full discovery, which can take a lot of time and cost a lot of money. Also, DOJ, their job is to litigate cases, so they're probably going to be more inclined to go to a trial. Whereas if you go to the Board of Contract Appeals, the agency is going to be represented by agency counsel. Those lawyers are going to be much more willing to negotiate. And frankly, all of the CPARS claims that I've been involved in, we would generally advise that you go to the board. That's probably going to be the most cost-effective, the most speedy, and the best chance of getting an early resolution, and hopefully getting the agency to take some action on the negative CPAR to either change the ratings, change the narrative, or change both. And certainly, as I should have said earlier, one of the most important things in a CPAR that can be the biggest hindrance is the final recommendation section of the CPAR, which says whether or not the agency would or wouldn't recommend you for the future. You're going to obviously want that to say that they would recommend you. So that's usually the fight with these is when you've got unsatisfactory ratings, marginal ratings, and you're in a situation where the agency is saying that they wouldn't recommend you for future work. So what's the process like here? The potential arguments that you're going to want to be raising if you're filing a CPARS claim are that the agency misinterpreted, failed to follow contract performance evaluation provisions. They breached their duty of good faith and fair dealing by incorrectly evaluating you, or they didn't act reasonably, or their actions were arbitrary and capricious, abused their discretion in rendering the evaluation. These are just kind of the buzzwords, but as counsel, this is something we can help you put together and compile. The pleading standard is that you have to plead facts which give rise to a plausible inference that the government abused its discretion in awarding the negative performance ratings. As I said earlier, the performance of rating has to be based on accurate, relevant facts. So more often than not, when we're challenging these things, we're arguing that the evaluation is not based on accurate or relevant facts. So you go through this process, you submit a claim, you get an adverse decision on the claim, you then appeal that to the board or the court. What's the type of relief you can get? Well, declaratory judgment is basically the relief you're shooting for here. That's going to be an order by the board or court interpreting the various clauses in the contract, the parties' rights, and deciding whether the agency breached its duty of good faith and or was arbitrary and capricious in making its evaluation. So essentially, you're going to, in that case scenario, from the board or court, you're going to get an order that says the evaluation was improper. Now, that being said, even though there might be an order like that, which would be a tremendous outcome on one of these types of cases, that's not necessarily going to mean that the CPAR itself is going to be pulled down from the system. While it might and very well could be pulled down to the system if there were such an order from the court, the court can't demand that the agency do that. It would behoove them to do it, but it can still remain in the system. And you could certainly, if you got an order like this, you could certainly try to advocate that it be taken down. But basically, what that declaration is going to allow you to do is, if you're bidding future work and the negative CPAR is still in the system for whatever reason, but you've now prevailed in challenging it at the court or the board, you can use that declaration when you're bidding future work to say, here, agency, just to let you know, you might stumble across this negative CPAR out there, but that CPAR has been determined to be the result of arbitrary agency action, so you should not rely on it. And if for whatever reason the agency chooses to still rely on it, that could set you up for potential injunctive relief. You could then file a bid protest, and you could argue that that the procurement official should not have relied on that because that CPAR has been deemed to be arbitrary. The Court of Federal Claims also has the authority to remand something to the agency, which means that although they can't direct the agency to revise or remove a CPAR, they can, if this seems like a viable case and you prevail, they can ask the agency, they can remand it back to the agency and give the agency specific instructions with what they're supposed to do. And that could result, obviously, in a revision to the CPAR. There's also one case here that I'll note that sort of potentially changes the game a little bit, because I mentioned earlier that CPARS claims are usually going to be the non-monetary route, which means you're going to be expending, unfortunately, legal fees to fight a CPAR, which could have huge implications on your ability to get future work. But at the end of the day, you might only be able to get a declaratory judgment, which means that you're not going to actually get any monetary relief. Well, there was a case recently that said that suggests that you might be able to recover some monetary damage in such a case. And the monetary damage you might be able to claim would be the costs that are going to be associated with addressing the unfavorable review on future proposals in the form of negotiations as well as protests. Like I just mentioned, if, for example, you get a declaratory judgment that a CPAR was arbitrary and capricious, and then an agency, after being notified of that, still relies on that CPAR, and then you've got to file a bid protest to get GAO to determine that that action and evaluation methodology was improper. Well, now you've incurred a bunch of attorney's fees. So it's possible that you might be able to recover those types of administrative costs associated with challenging and getting agencies to ensure that they won't rely on the CPAR in the future. So it's just another thing to keep in mind going forward in these types of appeals and claims. So long story short here, CPARs and claims and appeals, are they worth it? Well, I will note that cases I've been involved in and just generally speaking, litigation in general, but certainly in the area of CPARS, most of these cases settle or for whatever reason are dismissed before there's any sort of hearing. This makes a lot of sense given that contractors are not terribly likely, at least as of right now, to recover monetary damages. There's not going to be a huge incentive a lot of times, unless the CPAR is particularly egregious, to litigate once you start expending significant fees if the agency seems inclined to not negotiate. There's only been one published board decision that specifically addressed the merits of a CPAR. In other words, whether the CPAR was fair and accurate. And this case was not successful, but it is, ultimately the board determined that the CPAR was fair and accurate due to the contractor, in that case, the contractor's poor performance. But although this case was unsuccessful, it really is a significant turning point in the law with respect to CPARs and associated claims and appeals, because it confirms that the board clearly has the jurisdiction to review these evaluations, and that means that agencies are going to always know that there's a threat that these evaluations could be reviewed by a tribunal, and they certainly do not want the board or the courts looking over their shoulder and second guessing whether or not they conducted a fair evaluation of a contractor. So it just means that it increases, in my opinion at least, the chance of agency coming to the table during a dispute related to a CPAR and actually wanting to negotiate and revising the CPAR to more closely match the performance that's been documented by the contractor in their rebuttal, which obviously means that although I've been preaching this whole time here about how past performance and past performance evaluations are such a discretionary area for agencies, so this case confirms that although there's a lot of discretion here, if the agency abuses that discretion, if they make evaluations that are improper, and then they do their evaluation in such a way that's not based on accurate information, there's a serious chance that they could find themselves in court, and that's something they don't want. So I think this takes a little bit of that discretion away from the agency, and is certainly to the advantage of contractors out there that are trying to ensure that they are actually getting a fair shake when it comes to these evaluations. So some of the key takeaways here with CPARs: you want to carefully and timely scrutinize any evaluation you get and flag any issues you might see. You want to actively engage the agency early on, identify who's going to be contributing to the evaluation, and discuss any potential issues or concerns you might have. Once you get the actual notice that the CPAR has been posted, you want to review it with counsel and your team and identify any inaccurate statements, and you want to challenge those. See if the evaluation can be revised. If you're unsuccessful, submit a more substantive challenge or a claim, and make sure that you get all that information in within a 14-day time period from when you first get notice. In addition, while the rebuttal that you submit is being reviewed, you want, to the extent possible, see if agencies will hold off on relying on that initial evaluation, because, as I mentioned earlier, a lot of times they get changed between the initial and the final, and there's a strong case to be made that the agencies should be relying on accurate evaluations, and if it's not fully been considered by the agency yet and reviewed at a level above the contracting officer, it's arguably unfair that the agency rely on one of these before it gets to its final stage. And then if in conjunction with working with counsel, you conclude that the reviewing official's final decision on the CPAR was improper, you want to consider filing a claim. Litigation, obviously the board or the court can become costly, and there's pros and cons, and it depends a lot on how important this reference is and how egregious the evaluation is and things like that. But the first step of at least filing a claim can be relatively inexpensive depending on the scope of the claim. And often that can be something that maybe your initial comments and your request for a review was not taken as seriously or was not escalated to the proper channels within the agency. Certainly once you issue a claim, that's going to make things more serious, and the greater opportunity at that point that the agency is going to take this seriously and is going to review the file, going to review the documents you submit, and potentially sharpen their pencils a little bit and revise the ratings to ensure that they're an accurate assessment of your performance. So that is all I have for everyone today. I know that it was a lot of information, but thank you everyone for joining.